Hello, everyone, and welcome back to yet another session on polity and constitution. I hope I am audible as well as visible. Great, audible and visible. Let's wait for those to join and then we'll begin our discussion for the day. Okay, let's begin our discussion. Others can keep on joining in the meantime. So, we took up for discussion yesterday Article 19. And under Article 19, of course, you have some kind of rights. But beyond that, we also saw the restrictions on Article 19. Restrictions of various kinds imposed on the freedom of speech and expression, things like contempt of court, governed through a law called Contempt of Court Act, defamation governed through IPC Section 499, incitement to an offense, right? Various sections of IPC which put a check on hate speech. Then we have a law called sedition, which prevents any kind of hatred or disaffection against the government. However, despite this, we also know very well that there is an issue with sedition, and we saw the SG Wombat Kere case, where Supreme Court last year said that sedition is under cold storage now. There is absolutely no need to file any case on sedition till the government decides on the constitutional validity of sedition. Okay. Uh, Beyond this, then the other elements of Article 19 and the restrictions on them, whether it is the very infamous law called UPA or the restrictions on 19.1 D and scheduled tribes in interest of general public. Finally, we saw Article 20. Article 20 has three different elements to it: no ex post facto law, no double jeopardy, and no self incrimination. Then, the most important right is Article 21, right to life and personal liberty. Now, this Article 21 has two elements: due process of law, which was added later on, and a procedure established by law. Then 21 capital A, the last topic yesterday was the right to education. This is the law which provides for right to education to every kid in this country who is between the age of 6 to 14 years. So these are the grounds we covered yesterday. Today, we'll take up for discussion some of the remaining fundamental rights, and then, if time allows, we'll move on to DPSPs as well. Okay, that's it. Let's begin our discussion. But firstly, the five questions that we have every day. Starting with the very first question: Okay, so a lot of you got this correct. The question said incorrect. I hope somebody did not mark this by mistake and got the correct answer. The speaker can only act on complaints and cannot take suo moto action. Some of you got the right answer by mistake, which is no. Any luck favors the brave. What can we say? So speaker can only act on complaints. When somebody complains, the speaker acts on it. That's true. Whip is a constitutional office. Not at all. Whip is nowhere mentioned in the 10th schedule. It is nowhere mentioned. Whip has been borrowed from UK, but is not mentioned as a term anywhere in the 10th schedule. So this is wrong. So what is right? The right answer is B, because we wanted an incorrect statement. Okay, easy question. Then, second question. A lot of you got this correct. Some of you may have been trapped in this statement. It is the Advocate General. The concept of Solicitor General is at the central level only, not for the states. The remuneration of the Attorney General is determined by the President is actually correct, but it's the Attorney General of the country who is assisted by the Solicitor General, not the Advocate General. Two is wrong. Which statement is correct? A. Only one is correct. Solve this question. Okay, fundamental rights can be amended. It's the essence underlying the rights that cannot be modified. But rights per se can be modified. Therefore, fundamental rights will not be a part of basic structure, of course. Remove 3. D is the right answer. Because, of course, rule of law, separation of powers, welfare state, and a parliamentary democracy, they're all a part of basic structure. So the right answer is 1, 2, 4, and 5. Moving on to the next question. Did we get trapped into incorrect again? Don't tell me again some people got trapped in the incorrect thing. Okay. So, disqualification of legislators. Disqualified legislators can never contest an election. Of course, this is wrong. How can they never contest elections? They can contest elections after a certain period. So, for most cases, or for every such case, it is jail term plus 6 years. Now, disqualification cannot apply if the offense is a petty offense inviting punishment of less than 2 years. Absolutely correct. For conviction of an offense, it should be more than 2 years for petty offenses. Okay. Then offenses mentioned in section 8.1 will invite disqualification even for conviction without sentence. Absolutely correct. These two statements are correct. So, how many are incorrect? Only one is incorrect. Okay. Finally, last question for the day. Okay, a lot of you got C as the answer. I mean, which is pretty surprising. One is correct. Of course, advocate having more than 10 years of practice can be appointed a judge of Supreme Court or High Court. But a person who is a distinguished jurist, this concept of distinguished jurist is only for Supreme Court, not for High Courts. Right? So 2 is wrong. Hence, A1 only is the right answer. Now, one more bonus question for those who want to redeem themselves. Solve this question. Came last year. Sorry, this year. Okay, so due process of law. See, this question could easily be solved because these two mean the same thing. Yes or no? What is a procedure established by law? When we apply laws fairly, the application of laws is important. Law must be applied properly. The procedure has to be followed properly. So these two mean the same thing. Fair application of law and procedure established by law are the same thing. Then equality before law. Of course, that's not a part of due process, right? And principle of natural justice, the idea of ensuring justice, the idea of fairness. The law in itself has to be fair. This is the right answer. The principle of natural justice, and not a lot of you marked fair application, which is absolutely wrong. This is what is fair application of law, right? When the law itself needs to be fair, right? The fairness needs to be ensured. That is what is called due process of law. Okay, that's it. We are done with the questions for the day. Let's move on and discuss the topics at hand. Of course, the leaderboard. Let's look at the leaderboard. Janvi and Shreyank getting all correct. Very good. Then Kirtana, Himanshu, Fani, Surya, and Srihari getting 5 out of 6 correct. Then we have Shama, Govind, Pragya, Himanshu, Sumitra, Neeraj, Rakshit, Sanskar, Kaustubh, Kishan, and Hilo getting 4 correct. Most of you getting 3 correct or less. Okay. That's it. Let's move on. Article 22. The first topic today is Article 22, protection against arrest and detention in certain cases. For all of you, a very good piece of information. In case in future the police ever arrests you, right? Please immediately tell them, tell me reasons why you're arresting me. Because as per Article 22, I have a right to be informed of the reason of arrest. Now, they may slap you and all, but polity wins. You have made your fair point that I want to know the reasons for arrest. Number two, you have every right to consult a legal practitioner. So, legal practitioner, whenever police arrests you next time, don't call your friends, call some lawyer. If your lawyer is a friend, that's amazing. So, a legal practitioner, somebody who is practicing law, their help can be taken, and you have a right to consult a legal practitioner. So next time a police arrests you, say, I'll talk to my lawyer only. They may again slap you and stuff, but don't worry. As we know, polity wins. And lastly, whenever you are arrested, you must be taken to the nearest judicial magistrate within 24 hours of the arrest. Clear? So, within 24 hours, you have to be presented in court, then given the right to consult a lawyer, and then the reasons for arrest. Now, these three rights can be denied, will not be given, will not be provided to certain categories of people, like enemy aliens. Do you by any chance have any recollection of this word enemy alien? Under the chapter citizenship, we discussed enemy aliens. Okay. And when it comes to enemy aliens, these are citizens of those countries with which India is officially at war. Now, the other category of people who may not be given these kind of rights are people who are arrested under preventive detention. Preventive detention. So, what is detention? When you detain, arrest somebody, violate their liberty. Now, when you arrest people, in most cases, the arrest, the detention is punitive. Punitive detention in most cases, meaning after the crime was committed. After crime is committed. Punitive. But preventive means we arrest somebody before a crime has been committed. Maybe the person is a history cheater, habitual offender. We want to arrest the person even before he or she commits a crime. Think of this simple example. Whenever our parents leave our house, remember in your childhood days, mom leaves the house for 2 3 hours. What would she do? She would know that you will create some nuisance, so she would slap you, beat you beforehand only, so that once she leaves the house, you are well behaved for the next 3 4 hours. What is that? To prevent you from committing some act. That is called preventive punishment. So, preventive detention, right? Imprisonment of a person in anticipation of a crime. So maybe the person is a history cheater, a habitual offender. We know very well that in such situations, this person always ends up committing a crime. So before he can actually commit a crime, we'll arrest the person to prevent the crime from being committed. Then, preventive detention can be done on the grounds of security of the state, maintenance of public order, maintenance of supplies of essential services, and foreign affairs or security of India. So, on these grounds, the preventive detention can be done by making a law. So, laws on preventive detention can be made by both center and states. Why? Because it's a union list subject, entry number 9. It's also a concurrent list subject, entry number 3. So, both center and states can make laws on preventive detention. Clear? Now, when you are arrested under some PDL, preventive detention law, then what happens? Then the arrest is made and you can be kept in police custody for maximum 3 months. Within those 3 months, the police must take you in front of a judicial advisory board, meaning an advisory board which comprises of judges, somebody who was a judge, or somebody who is a judge, or somebody who is qualified to be a judge of the High Court. So, under preventive detention, if you are arrested, the maximum time frame for arrest is 3 months, within which the judicial advisory board must further advise. Now, the advisory board can say, okay, continue the arrest, or the advisory board can say, no, enough of arrest, now take the person to court, file a case against him, enough, or release him if no case is there. Now, when the advisory board allows further arrest, what is the maximum period of arrest? So, maximum period varies, it's not fixed. Okay, and this further imprisonment, laws on this are made by parliament. For example, there's a law called NSA. NSA, the very popular or infamous law, the National Security Act of 1980. Under this law, the maximum period is 1 year. Or Public Safety Act 1978, the maximum period is 2 years. So you can see very well how the police can arrest you and keep you behind bars without even telling you why they have arrested you, without even giving you a lawyer, without even taking you to court. Preventive detention. So there are various laws in the country for preventive detention. For example, the original law was the PDA, expired in 1969, or the very famous MISA. Remember MISA? This was the law under question in the ADM Jabalpur case, Maintenance of Internal Security Act, or as it was popularly called, Maintenance of Indira and Sanjay Act. Please don't use that. You use the Maintenance of Internal Security Act only. This law was repealed when Janata Party came to power. Then Coffee Posa, another example of a very popular law, largely used to prevent smuggling activities. Then the National Security Act, NSA. Then TADA. TADA has been removed now. It was there for 10 years. So TADA was a preventive detention law wherein the police would arrest you even before you had actually committed a crime. The police felt that there was a possibility of you committing a crime. TADA. This actor Sanju Baba, Sanjay Dutt, was arrested under TADA only. Then this is the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. This also a law where police directly arrests you, the Aryan Khan matter. And then POTA. What is POTA? The Prevention of Terrorism Act, the law which was made in the aftermath of the parliamentary attack in 2001. In that particular case, this law was made. This law was a very, very draconian law. Normally, I think yesterday I had mentioned this point also, that whenever you give any statement to the police while the police arrests you, you act as a witness against yourself. Those things can't be used in the court. So, whatever testimony, confession you make in front of police, the police cannot use it in the court. But POTA was such a law where if you make a confession in front of an SP, that confession could be used in the court against you. So the police could force a confession out of you, an SP is present, and then that confession could be used in the court also. Very dangerous draconian provisions. Anyway, when POTA was repealed in 2004, when Congress came to power, most of the sections of POTA were added in UPA. So don't think that POTA is gone. POTA remains very much. Now it has been revamped into UPA. These are some examples of PDLs in the country. Now, even if you are arrested under preventive detention, there are two rights available. As soon as maybe, the police must communicate to the people the grounds of arrest. As soon as maybe. ASAP. What is ASAP, or as soon as possible? For the police, ASAP is never. Why will they ever tell you the reasons? Then earliest opportunity will be provided to you for making a representation against the order. What is earliest opportunity? If you tell the police earliest opportunity, then of course that also means never. Okay. So this is with respect to preventive detention. That's it. We are done with Article 22. Now, as far as this right to freedom was concerned, it comprised of Articles 19 to 22. Now we have right against exploitation, very basic and very easy to comprehend. Two Articles 23 and 24. First up is Article 23, prohibition of traffic in human beings and forced labor. So, traffic in human beings and begar and other similar forms of forced labor are prohibited, and any contravention, opposition of this provision shall be an offense punishable in accordance with law. Okay. Traffic in human beings. Traffic, meaning buying and selling of people like commodities, not allowed. Immoral traffic in women and children, not allowed. Slavery, not allowed. Then the concept of Devdasis, banned now. So, what was this concept of Devdasis? So, in the ancient times, women, some of the women were married to God. This would mean that not married per se. In some cases, they were married. In other cases, they were devoted towards God, serving the God. So, some women were their lives were devoted to serving the temple and the temple deity for life. They would stay there only. And originally, this idea was again to ensure that there are people from society who ensure the temple is maintained properly. There are people who devote their life, sacrifice their life for the maintenance of the temple and the deity. But slowly and steadily, when some girls were married or were devoted to God and gave up their life for God and would stay in the temples only, the priests of these temples started sexually exploiting these women. And that is why the issue, which may have started in some very religious context, got a very negative turn and was misused by the upkeepers of religion. That's the beauty of religion, right? That the upkeepers of religion in every religion are the ones who misuse their post and power, right? Whether it is the Hindus, Muslims, Christians. So, one thing is very clear that these people at least know there is no God. If they had even a bit of belief in God, they would never be doing all these things, right? So, at least they know that there is no God. Anyway, so all these things are no longer there now. And as the article says, they shall be punished in accordance with law. What is the law? Again, a law is required. The law is required means it is a non self executory provision. Okay, this means a law was required, so a law was made. A very popular law is the BLA, Bonded Labor System Abolition Act of 1976. One more such law was ITPA. ITPA was originally called Suppression of Immoral Traffic Act. It was later renamed into ITPA. Why was it renamed? Look at this law, Suppression of Immoral Traffic Act. SITA. Sita, name of a Hindu goddess. So, to avoid this, they renamed the law. So, we have two laws, ITP and BLA, to ensure that such things do not happen. Now, what is meant by forced labor or begar? What is the meaning of begar and forced labor? See, as far as begar is concerned, Begar means when you are forced into doing something, compulsory work. Begar is begging. No, no, begar is not begging. Begar means compulsory work without any remuneration. So, if your parents ask you, mother asks you, come on, fill up the fridge with water bottles, that is called begar. No salary for that. Forced labor, when you are compelling somebody to work against their will, you may give them some money, but the person does not want to work. That's called forced labor. Like here, lot of you are studying because you are being forced into studying against your will. Have to wake up in the morning, right? So, begar and forced labor. But now you know Article 23, so you can use this at your own risk. Okay? Next time your parents tell you to do anything, tell them Article 23, polity wins. You may be slapped, you may be beaten, they may throw you out of the house also, no pocket money. But a true mark of a true aspirant, victory for polity. Okay? Please don't try all these things at home. The knowledge of polity should be limited to your paper only. It's too risky. Okay. Now, one more thing is, and very important, nobody else can impose compulsory work on you, of course, but the state can. Nothing in this article shall prevent the state from imposing compulsory service for a public purpose. So, state can impose a compulsory service for a public purpose. Okay. And in imposing such service, the state shall not make any discrimination on grounds only of religion, race, caste, or class. So, state can impose compulsory service, but they should not discriminate on the basis of religion, race, caste, or class. What kind of compulsory service are we talking about? Any example? A very good example is the military service, conscription. So there are various countries which have mandatory military service. Algeria, Angola, Cuba, Iran, Chile, Israel, both for men and women. So this actress, Wonder Woman, Gal Gadot, Gal Gadot is actually a member of the Israeli forces, a former member of Israeli forces because she served in the Israeli forces. South Korea, right? So these are countries which have forced or mandatory military service. Conscription is there. Now, can the state say that Pakistan is going to attack India? All the Muslims, come on, start fighting. Hindus will not fight. Can this be done? Tell me. Of course not. It can't be done. It can't be done on the grounds of religion. Okay. Can the government say all the men will start fighting? Tell me. Yes, it can be done. Religion, race, caste, and class. Gender discrimination is allowed. Meaning, only men, only women, this can be done. Class. Can a rich person be told that only rich people will fight, the poor will not fight? Again, no. Class is there. So, gender based discrimination can take place, but religion, race, caste, or class discrimination will not take place. Okay. One more thing, compulsory service for a public purpose. Let's say, take an example. Let us say you study properly, revise everything properly, and you end up clearing the prelims examination, move to the main examination, end up clearing the main examination, move to the what? Interview. Finally, on the date of the interview, you are going to the UPSC Dholpur House interview center, and you have taken bath after 3 4 months, right? Wearing your best possible clothes to impress the interview board, and then don't get lost in the dream. Please come back here again to reality right now. It's just an example. So when you go there, midway, a police constable stops you. He says that, where are you going? Now you are very sure of clearing the examination. You are very arrogant. You say, don't disturb me. I'm going for UPSC interview. Don't, if I clear, I'll transfer you immediately. He says, oh, okay. So since you are going for the interview, I'm sure you are aware that there is something called Article 23. You say, yes, of course. I know everything. Then he says, so can the state enforce compulsory service? You say, yes. He says, am I the state? Yes, Article 12, police is a part of state. Ajay Hasia judgment. Okay. He says, cleaning the roads, drains, public purpose. Yes, of course, it's a public purpose. So please, immediately start cleaning the road. He gives you a broom and says, sweep the road right now. Compulsory service, enforced by state for a public purpose. Can this be done? If yes, then write yes. If no, then give reasons why not. Don't write no. Give reasons why not. So, the correct answer is that such a compulsory service can only be enforced by a law, not by an executive order. So, the policeman can do it, but if there is a law, he cannot give an order for it. There should be a law. Are we clear on this? Compulsory service without any money can be enforced by the state through a law made by the state. That's it. That's the answer, right? No other answer. Some of you are creating some things. So don't create such things. Okay. Even though Sanchit is on a different track only. I'm not sure if Sanchit is actually a student or some kind of bot. He's copy pasting random things from here and there. Anyway, great. So this is Article 23. Moving on to Article 24. Now, Article 24 is the prohibition of employment of children in factories, etc. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Okay. So, no kid will be asked to work in any factory or a mine or be engaged in any hazardous employment. So, this Article 24 bans child labor. Now, please tell me, innocent aspirants. Can kids be employed, under 14 kids be employed as a domestic servant? Tell me, yes or no? Yes, in their homes. What kind of answer is this? In your home, you are a domestic servant. Please don't make personal confessions here. This is not the right platform for personal problems. So, for all our people who are mentioning that, this is not hazardous, etc., yes, they can be. Yes, I will like to tell you something. You'll be surprised. No, kids cannot be employed anywhere in the country. And in these domestic servants, dhabas, tea stalls, etc., since 2006 only. It's been 17 years. Where have you been? This law, which was there, Child Labor Regulation and Prohibition Act, originally it banned the employment of kids in 18 different occupations. But later on, since 2006, it has been banned to employ children as a domestic help, roadside dhabas, tea stalls, spas, etc. Since 2006, it is banned. Are we clear on this? Not before that. So please don't raise a statement. But Narendra Modi was a chaiwala when he was a kid. In that situation, there is no Child Labor Regulation Prohibition Act which banned it. Please. Clear? Okay. But in 2016, something amazing was done by the government, right? One of the very genuine steps taken by the government. So, because this child here refers to under 14, right? It is mentioned here. No child below the age of 14 years. So, please don't ask me who is the child. It's mentioned. We just have to read the statement. Uh, all kids under 14, because you also have to study, right to education, so it may conflict with your studies, so there's a complete ban on employing any kid under 14 anywhere, in any kind of occupation, any kind of profession. There are two exceptions. Exception 1, family run enterprise. If an enterprise is run by the family, and here also there's a very set definition of family. Okay, father, mother, unmarried sister, brother. That's it. Family does not mean uncles, 13th cousins, 17th daughter in laws, 14th son in law. No, 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 not that. Okay. And then audio visual entertainment industry. Audio visual entertainment industry. So, all these dance shows, singing shows, Indian Idol Junior, Dance Senior, whatever these shows' names are, right? In these shows, movies, theater, etc., the kids can be employed. Are we clear? It's a very important element. So, this is there. Now, with respect to minors, that is under 18, two categories. The Constitution clarifies that children under 14. And what about children under above 14? 14 to 18? Those minors are referred to as adolescents now. Okay. So, is there any adolescent person here? Please say yes. Let's see how many adolescent people are there. 14 to 18. And don't say I was. Everybody was. How nice. Okay, quite a few of you. Okay. So That is why some questions I get, I'll have to refrain from making remarks which are unsuited to your understanding. Okay, okay. Anyway, so for adolescents, people under 18, so all those innocent people here, right? You are not going to be working, and you will not be allowed to work. You are prohibited from working in hazardous occupations. What are hazardous occupations? Mines, minerals, inflammables. These are the three hazardous occupations. Okay, hazardous occupations. In case you want to know what exactly are these occupations, coal industry, iron ore industry, paper industry, bangle making, etc., please refer to Factories Act 1948, Schedule 1, download the law, download the schedule, see the list. Okay. Now, there is also punishment involved. What is a punishment? The punishment is either a fine or jail sentence. If you employ kids, 6 months to 2 years of jail. Fine is also there. Per person you employ, there's a fine of 20 to 50,000 rupees. Okay, and that's it with respect to Article 24. Now we must have seen, I'm sure, while I taught this topic, some of you must have felt that, oh, but I see kids begging on the street, employed in dhabas, etc., everywhere. If you find a kid employed anywhere, you can report to the police. You can report on the Women and Child Ministry website. You can contact some NGO and report to them. They will help you out in this. Are we clear on this? Never take matters in your own hands. Okay? Please don't go and try to be the savior. You are not a hero like this. And this is a true story. So, a few years back, a student did come to me saying, "Sir, you had said that we should report, take action, informed citizen, etc." So, this student, she saw some kids begging on the street, and she caught one of them and said, "Come on, I'll take you to the police, etc., or I'll inform." And when she started asking the kid, "Who is employing you? Where are you working? How are you working?" etc., the kid started shouting, "Kidnapping, kidnapping." And people came there. Okay. So please don't do all this on your own. Don't play the hero. And it could be a very difficult situation for you if you end up like this. So please inform the authorities. Let them do the task. Okay. And for those who are, I think couple of you have mentioned that whatever child wants to, children under 18, children under 18 have no right to give consent. Okay. So people under 18, you also here in the class, you have no right to give consent for anything. Okay. So your will does not matter. Will any kid want to study? Of course they won't want to study. They don't understand what are the repercussions. So kids under 18 have no right to consent. Afreen, sir, government should ban children reel making. What happened, Afreen? Did somebody make a better reel than you or what? Why are you worried? Let them make reels. What's the big deal about it? Okay. It's okay. I mean, to each his own. Why to be so harsh? Somebody says there should be a law. Cringe content. Wait, Shri. Yes, their reels are weird. They are going on a wrong path. How moralistic. If the if we are out somewhere and the police comes and then we say, oh, moral policing is happening, we try to do the same thing. Let them also have fun in their life. Let them enjoy. Let them live their life. Once they are mature enough, they will understand. It's okay. Sometimes a bit of fun and frolic and cringe-worthy behavior is justified. Don't be so harsh. It's okay. You're also a kid once. Okay. Anyway, so that's it. Let's come to a question first, and then we'll move on to Articles 25 to 28. Please mark the answer here. A lot of you got this correct. Which of the following are envisaged in the right against exploitation? So we have two articles, 23 and 24. Just mark those two articles. Prohibition of traffic in human beings and forced labor is Article 23, which is envisaged by the right against exploitation, which is under the right against exploitation. And second is the prohibition of employment of children in factories and mines. This is Article 24. 1 and 4 are a part of what? Part of right against exploitation C. 1 and 4 is the right answer. Okay. Then abolition of untouchability, Article 17, and the protection of interest of minorities, 29. So, of course, these two are not a part of right against exploitation. Okay, that's it. Now, coming to freedom of religion, Articles 25 to 28. Before we begin this discussion, I need to take a poll. I'll give you 10 seconds. People who believe in religion, mark A as the answer. And people who don't believe in religion, meaning they don't believe in anything, nothing, no God, no superpower, no magical power, no uh, such power which exists, no energy, nothing. Mark B. And if you believe in any such thing, whether there is some kind of energy, some kind of spirituality, you mark A. Are we clear on this? Don't mark other options. If you believe in religion, mark A, otherwise B. Somebody marked C also. That's why I chose E as the right answer, to avoid any problems in the polling. So everybody got this wrong, right? So polling, the leaderboard remains intact. 88% believe in religion. Okay, great. Of course, believe in God but not in religion. It's okay. It's okay. You believe in some kind of magical power. Okay, some kind of larger power, energy, spirituality, whatever you may call it. No problem. So to all these 88% people, I would simply make an earnest request. If by chance I say something which hurts your feelings, please don't come after me. Okay? Let it be a part of the class discussion only. Don't be angry. Other 28%, they are of no concern to me. They'll hardly get offended. But for the remaining people, I'm not sure who I might offend with this particular provision, right? So, and of course, aspirants have to be believers in God, at least till the exam is there. Whatever help comes from whichever direction, you have to take it. So, freedom of religion, Articles 25 to 28. First up, Article 25, coexist. Nice tattoo work. You can get a tattoo done on this particular design also. Article 25 says freedom of conscience and free profession, practice, and propagation of religion. Profession, practice, and propagation of religion. So, what exactly is this? Now, please understand a very logical point here. In most of our fundamental rights, we saw that the right was given to us by the article, and then the article goes about to impose restrictions. Okay. But Article 25 is exactly opposite. Subject to public order, morality, and health. This article starts with restrictions and two other provisions of this part. So let me remind you, the right you are going to see right now is the lowest in the hierarchy of all the rights, because every other part or provision of this part 3 is actually a restriction on your freedom of religion. Are we clear? Every other article of part 3 is a restriction on your freedom of religion. So, freedom of religion is given the lowest hierarchy amongst all the fundamental rights and subject to things like public order, morality, and health. All persons are equally entitled to the freedom of conscience and the right freely to profess, to practice, and to propagate religion. What is conscience? Four words: the freedom of conscience, right? And the right freely to practice, to profess, propagate your religion. Conscience means inner relationship with God. In what form or manner do you want to mold your relationship with God? You are free to decide that. Nobody is telling you what to do. It's your choice, your life after all. You believe God lives in temple or mosque or church, gurdwara, good for you. You believe God lives in books, good for you. You believe God lives in parents, that song from Hum Saath Saath, ये तो सच है कि भगवान है. Or you believe God lives in somebody you love, तुझ में रब दिखता है, it's your personal problem. Nobody cares. Are we clear? You are free to mold your relationship with God in whatever form or manner you want. Nobody is stopping. Okay. Second thing, you have a right to profess, proclaim your religion, the freedom to profess your religion. So, you are free to proclaim, like some people have proclaimed that I believe in God, I believe in this religion, or I don't believe in religion, but some God, I believe in spirituality, all this. You are free to profess it, proclaim it publicly also. Some people say I'm an atheist, some say I'm an agnostic. You are free to publicly say all these things. Nobody will punish you for that. Third, practice. You are free to practice your religion, to carry out your rituals. Of course, they should not violate public order, health, morality, etc. Now, when it comes to professing your religion, there are various visible manifestations of how you profess your religion. For example, somebody can wear a tika, somebody can wear a turban, somebody can wear a skull cap, etc. Now, in the Constitution, in the same Article 25, under the explanation, it has been mentioned that the wearing and carrying of kirpans, this is a kirpan, okay? Kirpan is more like a knife. kirpan shall be deemed to be included in the profession of the Sikh religion. So carrying a kirpan is deemed to be a part of Sikh religion. So in case you carry a knife somewhere, kirpan is like a knife only. You carry a knife somewhere, you may be stopped. Say an airport. Remember, if you carry a this nail cutter, which has a very sharp knife inside, that knife is so sharp that you can even cut diamond with that knife. No, anyway, but the point is that that knife can be used to poke. It can be a hazard, but still, you are not allowed to carry that knife. But for Sikh people, they're allowed to carry a kirpan. It could be symbolic of a knife. Don't think that they are carrying some sword only everywhere, but they can carry a kirpan. It is a part of professing their religion. Okay, that's it. Lastly, to propagate, transmit, spread your religion, market your religion. That come on, my religion is the best religion. Other religions, useless religions. Come on, join my gang. Profession, propagating your religion, transmitting, spreading your religion, the doctrines of the religion. That's called propagate. And a very important point is this: you have a right to market your religion. Does it mean you have a right to convert other people? Yes or no? What do you feel? If you have a right to market religion, should you also have the right to convert other people? No right to convert? Then why the hell would I market? If not forcefully, some of you are saying not forcefully, okay, more logical. What is forceful? That's also a problem. How to define forceful? See, this matter came up in the courts in 1977 only, because two states, Madhya Pradesh and Odisha, these two states made laws. Odisha in 1967 and MP in 1968. These two states made what they called was an anti conversion law to prevent conversion, because in these areas they felt that the Christian missionaries were converting, targeting, and converting the tribals forcefully. Now, these two laws made by these two states were challenged in the court, Supreme Court. Firstly, the High Court, then the Supreme Court. So, in the Madhya Pradesh High Court, the High Court said that this law is correct. In the Odisha High Court, the High Court said no, the law is wrong. Different opinions matter into Supreme Court. So, in the Stanislaus case, Reverend Father Stanislaus, 1977, Stanislaus, Stanislaus. In this particular case, 5 judge bench, it gave a judgment. It said, right to propagate, right to propagate does not include right to convert if conversion is obtained via what? If conversion is obtained via force, fraud, or allurement. Okay, what is force? Though Supreme Court has not defined these three words, but we can understand force could be forcing somebody to convert, maybe a physical pressure, etc. What is fraud? Tell me. And what is allurement? Lure somebody, entice somebody, trap somebody. What is fraud and allurement? Tell me. Give me an example. Don't give example of money. That is understood. You can give some money and tell people, join my religion. What would be a fraud or allurement? Brain drain? Honey trap? False claim, giving false promises. Okay. See, one thing that we understand is that you can lure people through money. Money in different forms. Give them food, give them job, promise them some education, etc. This is all a part of giving money only. What else can be allurement or fraud? Join my religion, it's the best. Right now, your life will remain the same, but after you die, you'll have an amazing afterlife, right? So basically, you are promising something to people that once you join my gang, I mean, sorry, join my religion, life is amazing. Please, my religion is the best religion. The problem is every kind of marketing that happens, every kind of marketing for any kind of religion is actually all allurement only. There's no proof. For all those believers here, please don't mind. But whatever you believe in, whatever magical power, God, spirituality, etc., energy, source, and all, there is no proof of it. I mean, of course, the fact is that it's your belief. You may have felt it intricately, deeply, but if I ask you, can you prove it right now? If there is a God, let something happen to me immediately. Will that work? That won't work like this, right? So that's a problem. It's a belief. So I have nothing against that, but it's a belief system. So whatever any religion says can be deemed to be allurement only, right? So it's such a vague thing that allurement. These words, if you use these words, then nobody can practically convert, because whatever you do, if let's say I want to convert to some religion by reading some book, somebody can claim that, see, that book is alluring you and hence you have been brainwashed. When some people said that conversion should be out of conscience and free will, I cannot generate random free will. Yes or no? Right? I can generate free will only based on some things I know. And how will I know things? When you, the upholder of religion, God, spirituality, you tell me about it. So I have to believe you. And what's the proof there? That's also allurement. This is a problem. These words are so vague that practically every kind of conversion, even on free will, can be questioned. Of course, this judgment came from Supreme Court. A. N. Ray and all such judges were there. So what else could we expect? Remember A. N. Ray, Keshwan Bharti, Indira Gandhi. So, but this judgment is improper. There should be very proper definition of what is force and fraud, etc. Otherwise, it is prone to misuse, which is what has happened in the country. You see, all of you here, I believe, have this belief that free will should prevail. If somebody wants to convert freely, then they should be allowed to convert. But all these states across the country have anti-conversion laws. You go to Arunachal, they made a law in 1978. You go to Chhattisgarh, a law in the year 2000. You go to Gujarat, right? There also exists a law since 2003. You go to Himachal Pradesh, a law in 2006, 2019, both occasions. You go to Jharkhand, a law since 2017. You go to Uttarakhand, a law since 2018. You go to UP, a law in 2020. All such states have made similar anti-conversion laws. And in case you want to convert in all these states, you need to give or need to get the approval from district magistrate, need to give notice to DM, SDM, etc. 15 to 60 days of prior notice needs to be given. Do you have to give any notice to write an article in the newspaper? Do you have to give a notice to others to enjoy your other freedoms or rights? No. Then there are penalties also, punishments for conversion, punishments for supporting conversion, punishments for forceful conversion. Which can be jail term. Look at the jail term. From 1 year to 5 years. Fine. The fine in such cases can range from 1,000 to up to 50,000 in some states. So harsh is the law. Okay. Notice to convert. You have to inform the DM to convert. Do you think it is justified? If we have to go through all this ordeal to convert, then what is the point of giving this right? Don't give this right only. So this is a problem. This judgment needs to be revisited. We have to categorically define what is force, fraud, etc. And do you think it has stopped conversions? It is still happening. If there is anyone who can say that there is no conversion happening forcefully, I'll tell you. If there's a poor person who has no money, no food for family, you tell him or her, uh, please take this money, join my gang. And he will join any gang you want. He will join any religious group you want. His target is to feed his family, right? He has no worries about what is your God, what's your drama worship. It's okay. Will you give his family food? Okay. So is it justified? It is morally wrong. This is also force and fraud only. So these things are happening in the country, sadly, and these laws are not able to prevent it. So the bigger problem is to clearly codify these laws. And there are allegations against amazing people, great people. So why should we make any allegation against anyone? But these Western philosophers, thinkers, etc., media persons, scientists, they make allegations. Allegations even against Mother Teresa, who attained sainthood, the Sisters of Charity, that these people used to convert people on deathbed. Dying people were converted. Before dying, please join me. Allegations made by Christopher Hitchens, Richard Dawkins, all these people, Sam Harris, and all. I'm not making any allegation. They are saying all these things. So the problem is that we need to clarify what exactly is this force, fraud, and allurement. These vague words won't work, right? And after all, if you are so uh, scrutinizing these things in such depth, then we have to have very important proper checks, because these are very subjective. Why does somebody convert and why does somebody not convert? Based on free will or not, it's highly subjective, because there's nothing called free will, right? You can always be brainwashed into something. That's a big problem. Anyway, right to propagate as of now does not include right to convert if conversion is obtained via force, fraud, or allurement. Okay. Now, coming to the second part of this article. So, have you observed that recently a law was made on triple talaq being removed as a practice? Yes or no? Are we aware of this? Okay. or the government has on various occasions made various laws, etc., to eradicate and remove some very abhorrent negative practices in a religion. Human sacrifice, animal sacrifice, all these things are slowly and steadily being removed from what? From the country. Uh, Even though your religion may allow for it. The bigger question is, how is the government able to interfere in your religion? This is the clause of Article 25, very important. Remember this clause. This is a clause which allows the government, the state, to interfere in your personal drama, in your religion. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law, regulating or restricting any economic activity, any financial activity, any political activity, any other secular activity which may be associated with religious practice. If your religion says open schools, or some religious group opens a school, opens a hospital, etc., then your religious practice is a matter of religion, but running a school, running a hospital, that is not. That's a secular activity. It is not dependent on religion. So you cannot say, in my hospital, I have opened this hospital, so only a Hindu priest will come and perform operations, or only a Maulvi Imam can come and conduct operations. No, 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 sorry. This will not happen. Are we clear on this? So if you are running some secular activity, that can be regulated by the government. Number two, and very important, providing for social welfare and reform. Social welfare and reform. The state can make a law to provide for social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. So, throwing open of Hindu religious institutions. This was in response to denial of temple entry. So here Hindus, the article explains, Hindus here would mean not just Hindus but also Sikh, Jain or Buddhist. So the state can open, throwing open Hindu religious institutions. Throwing open doesn't mean throw it. It means opening the gates. Okay. So throwing open means the gates are open now for every person to enter, because largely in the Indic culture we saw that some communities were denied temple entry. Okay. So this was with respect to the provision of social welfare. Are we clear on this? This is what says that our state can interfere in your personal practice. A law can be made to interfere in your personal drama. Are we clear on this, everybody? So you cannot claim absolute right of religion. It is not possible. Apart from the fact that there is morality, health, public order, other fundamental rights, the state can still interfere in your rituals, practices, and can curtail those rituals and practices. Okay. This is Article 25. Gauri, Clause A. Regulating or restricting any economic, financial, political, or other secular activity. If your school or college, if your religion runs a school, runs a hospital, etc., then the state can regulate those schools and hospitals. Can regulate. If they want to, if they feel like it, they can regulate it. If they feel things are going wrong, they can regulate it. Now somebody says, explain Clause B. What is this here? How better can it be explained? I sometimes am aghast at this. Either you are not paying attention, wasting everybody's time. Anyway, let's not waste time in this. So I'll explain this again. Next time I won't. There's a live recorded video available. Please watch it again and again or pay attention. Don't daydream. So providing for social welfare and reform, meaning in case there is any practice in your religion which say violates dignity of an individual. Now triple talaq, for example, right? It created inequality, was prone to misuse also, largely amongst the Muslim community only. And there were people, the agents of religion, who would try to get around this by getting the woman married to somebody else, consummating the marriage, then making her eligible to be married to the husband again. So all these things were happening, or various other practices. If there is any practice in your religion, let's say human sacrifice, if today your some baba comes to you and says, if you kill one human being and give that sacrifice to God, you will clear UPSC top 5 ranks. Of course, that's stupid. We have to regulate it. Agents of, there's nothing called agents of religion. I mean, even if I try to use some kind of statement like agents of religion, somebody is asking what is agents of religion. Please understand sarcasm here. I can't explain sarcasm. What school kids am I referring to here? Upkeepers of religion, people who call themselves the ones who are in charge of upholding the religion, right? So that is their agents of religion. By my mistake, use the word agents of religion. Ignore it for now. Let's understand that these are people who are self-professed, the bosses of religion. So this is Article 25, Clause 2. Two things. Number one, state can regulate any secular activity which may be associated with your religion. Number two, state can interfere in your religion and remove any kind of practice which can bring social welfare and reform. Okay. Now, we are done with Article 25, and it's right time now for us to also understand a very important term, which is secularism. Firstly, secularism has a specific definition. This word came in the West. What is secularism? I am writing it. I am explaining it. Patel, calm down. Secularism has a specific definition to it. The definition of secularism is strict separation between state and church. Church is symbolic of religion. So, separation between state and church. Church symbolizes religion. So, this definition came from the West, actually. Okay. Now, what does the definition mean? Strict separation. State will not interfere in the religion, and religion, you stay away from the government. Your religion is your personal drama. Okay? Keep it separate. So, this is also referred to as the Western model of secularism, in the sense that the state will not interfere in affairs of religion. In affairs of religion. Sumitra says, state does not, but center can. This state refers to the nation, the country, the governing powers in the country, not the state government or central government. So, state will not interfere in affairs of religion. Second thing, it also means the state will not provide any kind of support to you. Sorry, no support. But this also means that we will not create any hindrance. No hindrance. No obstruction. Okay? You are free to practice it within the private space. Please keep it there only. Please don't bring it in public. And we are not responsible for your personal drama. Do it at your own risk. We won't interfere and we want you to keep it to your private space. Now, this looks so nice, that state so independent. But there's a problem. What if a larger group which follows a religion tries to dominate a smaller group? The state will say, no, sorry, I can't interfere. What if within a religious group, the males dominate the females because the religion tells you to? So, any inter or intra religious discrimination cannot be removed. Cannot be removed. Cannot be removed because the state is independent, does not want to interfere. So, this may result in a feeling of nervousness, anxiety, a threat looming over the heads of all the minority communities. That state cannot come and protect me if my religion is being subsumed by the larger religion. Nobody will help me out. I'm on my own. This is a Western model. But India follows a different form of secularism. It's very unique. It is a more positive approach towards secularism. So, what we say is that yes, state has no religion. Agreed. But support to all religions will be provided equally, no problem. However, what is very important is that we can interfere. State can interfere to prevent what? To prevent discrimination. To prevent discrimination, the state can interfere. This is what is the crux of Indian secularism. We call it principled intervention or principled distance. Both can mean the same thing, though exactly opposite. What is the meaning of this? Principled intervention or distance. Principled intervention means based on some logic, the state can interfere. And this comes from which article? The source of it is Article 25, Clause 2, that the state can interfere in your religion if it feels that some practice, some ritual is impacting the some sections of your religion, impacting the marginalized, the weaker sections, the women, etc. Then we can interfere and we'll remove that practice. Sorry, this practice not allowed. This is the beauty of Indian secularism, that we allow for interference, but based on some principle, not random interference, based on some principle, based on some logic, based on some criteria. That can depend. on a case to case basis. Are we clear on this Indian model of secularism? So, what I'm teaching here, how many of you already knew this? Tell me. Or you must have studied this somewhere. So, tell me, where have you studied the same kind of concept? So, all those people who were studying this book, Political Theory, you would know very well that chapter 8 of this book, Political Theory, explains the same concept, drawing a comparison between India and which country? Tell me. Let's see how much you remember. India and USA. Drawing a parallel between the Western model and the Indian model, USA and India. USA is a representation of Western model. Very good. So that's it. For others, now you understand why this book is important. It will tell you a lot of important information. I hope this point is clear now. So Indian model is based on interference. If let us say today Hindus dominate Muslims, or Muslims dominate Hindus, or Christians dominate Buddhists, whatever, this is called inter-religion domination. Here also state will interfere. There is equality. And if within your fold, if amongst Muslims, Ashrafs dominate the Pasmandas, or amongst Hindus, say the Brahmins dominate the Dalits, the government can interfere within your religion also and amongst religions also. Intra, inter. Intra is inside a religion. Inter is between religions. Any kind of discrimination, domination will not be allowed. Clear? That is all as far as secularism is concerned. I think it is not that difficult. Supreme Court could have clarified what is secularism in the SR Bommai case. Sadly, they did not. Moving on to now article. Oh, we should have one misplacement of position. Anyway, now this is article 26, freedom to manage religious affairs. So very, very important is this article 26. You are free to manage your own affairs in matters of religion. This says subject to public order, morality, and health, not to other parts. Every religious group, every religious denomination, or any section shall have the right to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. See, look at this. The right to property not available to us as citizens, individuals, but religious groups still enjoy a fundamental right to property. And look at this very, very important provision. Every religious denomination or religious group has a right to manage its own affairs in matters of religion. Right to manage its own affairs in matters of religion. Did we understand this point? That you have a right to run your own religion. Okay. Now comes the issue that largely is under discussion. Now, let me just clarify one more thing here. This matter is under Supreme Court's jurisdiction now. It's sub judice, so a final conclusion will not be made. I'll just point out what is the case, what was the judgment, and what is the current situation. So this Sabrimala issue, I think most of you would know it, but when it comes to Sabrimala, Sabrimala was a temple considered to be the abode of Lord Ayappa, which is located in the Periyar Tiger Reserve, right, in the Western Ghat mountain ranges in Kerala. So we are referring to Lord Ayappa. Lord Ayappa is a 12-year-old child god, and Lord Ayappa Manikandan, the temple was constructed by Rajsekhara, Lord Ayappa, son of Vishnu in his avatar Mohini and Shiva. Now, this temple had a practice because Lord Ayappa had taken a vow of celibacy. He will remain celibate for life. Brahmacharya, for those who don't understand, Nashtik Brahmacharya, vow of celibacy. Now, women were not allowed entry in this temple uh, because this lord had taken a vow to remain celibate, brahmachari. Back in 1960s, there was a very important rule made by the Kerala government. This Kerala government rule was called the Kerala Hindu Places of Public Worship Authorization of Entry Rules. We normally call it as Kerala Public Worship Rules. Public Worship Rules. So, in the year 1965, a Rule 3B was formed which said that since the Lord is a brahmachari, Nashtik brahmacharya, women of a reproductive age, 10 to 50 years age, women between 10 to 50 years of age will not be allowed what? Temple entry. Okay, not allowed temple entry. So this rule came from the Kerala government, not by the temple authorities. This 10 to 50 years age band. Now, why 10 to 50 only? So ideally, the concept was based on menstruation, reproductive age. So normally, a girl child would start menstruating in say around 12, 13, 14. It can be as early as 10 also in general, uh, unlikely before 10, though it can be found to start at the early age of 9 also, rare circumstances. So a rough age of 10 and the maximum age of 50 was considered to be the reproductive age for women, where they can reproduce. Anyway, this matter was challenged in the Kerala High Court in 1990s only. In 1991, this S. Mahendra case, the Kerala High Court had upheld this practice as constitutional. Okay, declared constitutional by Kerala High Court, 1991. Right, that was the S. Mahendran versus Secretary Travancore case. Now, in 2006, Young Indian Lawyers Association, sorry, Indian Young Lawyers Association, they filed a PIL before Supreme Court, saying that this is violating the right to equality under Article 14 and also violates right to freedom of religion. Article 25, you are denying entry of women in a place of worship. Now, the issue here was that the state said that the temple's priest controlled this. Article 26, Clause B says that the state has a right to manage their own affairs in matters of religion. This conflict reached Supreme Court. Case was filed, 2-judge bench, 3-judge bench, 5-judge bench. Finally, in 2018, a judgment came. Supreme Court judgment with a 4:1 judgment. 4 judges in favor, 1 against it. Supreme Court declared this practice to be exclusionary and unconstitutional. Practice was declared exclusionary and unconstitutional, meaning women were allowed entry in the temple. Okay. Now, the one judge who did not vote or voted against it was Justice Indu Malhotra, the only female judge in the panel. Anyway, what is more important is to know the reasons for why the Supreme Court uh, made such a judgment. Number one, Supreme Court said that this kind of not allowing entry of women denudes women the freedom of worship. It also said that state can bring social reform, which is hilarious because Supreme Court said the state can bring social reform. Sadly, they did not understand that under Part 3, the definition of state does not include judiciary. So they cannot bring social reform in religion. But who will tell the bosses, my lords, that my lords, you yourself had said a few years back that you are not a part of state. How can you now become part of state? Anyway, then our judges also said that this subverts the idea of autonomy, liberty, dignity. And they said that stigma is attached to menstruation, which has no place in the constitution. Stigma attached to menstruation. Or they invoked, you'll be surprised, Article 17, saying this amounts to untouchability. Why? Because Article 17 does not define untouchability, and it was done deliberately to cover everybody. My lords, if you look at the debates in the Constituent Assembly, that's not why we had Article 17. Article 17 was meant for a specific purpose, for the scheduled castes. Let's not dilute that. Number two, there are a couple of issues here. Number one, this, of course, misusing Article 17, introducing Article 17. Why was it done? Because if you try to match somebody's right to enter a temple and the temple's right to manage its own affairs, what prevails? Article 26 will prevail because Article 25 is the lowest fundamental right amongst all the rights. So they had to invoke Article 17. Secondly, a very improper thing. What is a stigma attached? See, the religion does not attach any stigma. If you personally are attaching a stigma, that's your personal problem. Because the same religion, the Sanatan or Hindu religion, it allows or it worships menstruation. If you go to Kamakhya temple in Assam, this practice is worshipped. That's based on this concept that uh, Shiva and Shakti. Shakti's body was cut into various parts, 52 parts or something, and one such part fell in Kamakhya. So the practice of menstruation is worshipped. So this idea that this is untouchability and all, it's a very kiddish idea to invoke Article 17. It does not work like this. But anyway, this matter, and one big problem is that Supreme Court has taken upon itself to decide what is essential in a religion and what is not. This is what is known as essential religious practice doctrine. Okay, so this is a very unique concept which has come in the Shirur Mutt case 1954. This was a 7-judge bench where Supreme Court says what kind of practice that you follow, what kind of practice you follow in your religion will be whether it has constitutional protection or not, we will decide. What practices are essential to a religion and they will be given the protection of Article 25, we decide. And how will you decide? You will decide based on the doctrines of religion, evidences, people's behavior, practices, long standing practices. So, in all these situations, the court said we'll rely on religious doctrines and people's behavior. Religious doctrines, most of them are made in times which were deeply patriarchal. You are going to rely on religious books. Number two, on human behavior, which is prone to misusing and misunderstanding and misinterpreting the books. What are you relying on? The and are judges experts in matters of religion? Are they theologians? This is an area which is beyond the competence of Supreme Court. Frankly, this is an area which is beyond the competence of Supreme Court. And I think one such point is very clear, that due to this essentiality doctrine, judges have now are assuming a theological mantle which they are not expected to do. Right? Now the judge is more powerful than the entire religion, and his voice is as strong as that of God. So you have crossed the boundary, a classic example of overreach. And there are other issues as well. Young Indian Lawyers Association filing a PIL. Where is the locus standi here? I mean, see, I'll tell you something, don't mind this, but anything you do in your religion is extremely funny and hilarious for an atheist. If somebody does not believe in your belief in God, they will find everything you say about your God, spirituality, the cosmic power, superior being as funny, because you can't prove it. It's your belief only. So, why should a non believer be so worried about this? Number one. Number two, for most women, they themselves, if you ask them, please enter a place of worship while you are on your menstruation cycle, they will not enter on their own because of the ingrained belief that this is how you, these are days where you don't worship. It comes naturally to those women who are believers. And if you're a non believer, then why the hell do you care about a temple? Ignore it, boycott it. That's not how religion works. You have to believe in it or else ignore it. So, religious place of worship is not a tourist spot. Sadly, this is a problem in our country. We have made these places tourist spots where people come, picnic, come with couples, and it is surprising that these people claim that they believe in God and they go to temples as couples and perform activities which largely would bring to shame the gods themselves. So this is a very sad state of affairs. And then you claim I believe in God. At least, please don't claim that. Apart from this, uh, this role that we have occupied, that we will tell you what is right, what is wrong. I am telling you that women, you are being denied entry into temple. That is violating your fundamental rights. Come on, enter the temple. It's just like telling women, you're wearing hijab. You are being violated. You are being suppressed. But ask her also. What if she wants to wear a hijab? What if she does not want to enter the temple? So, this approach that you have in telling women what is right, what is wrong is a big problem. Let them decide what is right, what is wrong. I think they are adept at deciding what is right and wrong. If we become the moral guardians of how things are, that would not be appropriate. The same thing goes for the hijab case also, where the judgment is reserved as of now, but all these things should be left for people also to decide. And what can be a conclusion here? As of now, there is no need to make a conclusion. Let the court decide, because this matter anyway is under review in front of a 9-judge bench. A 9-judge bench is going to decide on this matter, not just this matter, other matters also. Matters on entry of women in the place of worship, entry of Muslim women also in their place of worship, entry of Parsi women also. So Parsis, if they marry a non-Parsi, they cannot enter a fire temple, the women. Or this practice of female genital mutilation among Daudi. Am I audible now, guys? Audible and visible? Okay. So, taking from the last point, this matter is pending in the court right now, right? This case is the Kantaru Rajivaru case of 2018, and it is pending in front of a 9-judge bench. The matter of Parsi women not being allowed entry, the practice of this female genital mutilation amongst Daudi Bohra communities, all these things are pending in the court. So we have to also understand that the right approach would be to let the parliament make a law on this regard. And if you are asked a question in the or in the interview, what is your stand? Please refrain from making a stand. If you believe that they should be allowed entry, or if you believe they should not be allowed entry, it is very risky. You don't know what the board thinks. It's a very personal kind of topic, and most people will not be able to keep themselves separate from the topic, right? So the problem with most people who are believers is that they believe in the ritual very strictly, and non-believers, they suffer from the bias that whatever believers do is wrong only. That's also wrong. So some of you modern people here might think, oh, this is biased opinion. You are biased in his own biased approach. This opinion is not biased. This opinion is based on understanding the larger social construct in society. That when you make any kind of change, it should come from the larger societal group, the parliament, which is a visible uh, manifestation of the society, not the judiciary. So let the parliament make a law in this regard. If the parliament makes a law, entry will be allowed, come what may. If they don't make a law, let it be. It's okay, right? And this should be your standard answer in the interview as well. That what I feel is that the better approach is let the parliament decide, since the courts are not experts in such areas. It is not their expertise, so it would be improper to let the courts decide on such matters. That is your conclusion. I hope this point is clear to everyone. No, Surya, before 1965, nobody was allowed, but after 65, the age band was set. Clear? What were you saying about dowry? Twisha, where did dowry come from here? Who is planning to take dowry? Think about dowry only in the examination. Clear the exam first. Okay? And don't take dowry, please. Okay, so the present status is this matter is under review in the court, and the court will decide on what is right and wrong. Vivek, oh, of course, I expected this from you. How can illiterate MPs judge these cases? Amazing. What is the data to show that MPs are illiterate? Don't make such statements. Please. These reflect lack of knowledge. Okay, guys, let's take a break. Be back at 8:15 and we'll continue our discussion further on this. Break till 8:15. Enjoy a long break. Let's come back. Welcome back, guys. Sir, your voice. Achha, my voice is not coming. I hope it's coming now, audible and visible. 2 minutes of extra time, full on enjoyment. Moving on now to the next two articles. Don't expect any question from Sabrimala. Till the judgment comes, it is extremely unlikely that a question from Sabrimala will be asked in the examination. Now, Article 27, freedom as to payment of taxes for promotion of any particular religion. So, back in the medieval times, we had this concept of jizya, if you remember. Jizya, which was imposed only on the non Muslims. They were called zimmi, protected subjects. Tax was imposed on them. That's called jizya. Now, such kind of taxes will not be imposed on particular communities, right? So, no person shall be compelled to pay any kind of tax, and the money collected from that tax will be used for the benefit, the promotion, the maintenance of any single religion. So, that will not be done. Okay, let me just clarify one thing here. There's a misconception that the government cannot spend money on providing maintenance for religion. It can. A small amount of money being collected by the government is being spent on providing convenience that is not violating Article 27. I'll repeat once again. In the Praful Goradia case 2011, Supreme Court has said that if only a small amount, a small part of any tax collected is utilized for providing convenience to any religion, that will not violate the constitution. There are various such examples. Kerala government annually pays 46.5 lakhs to the Travancore Devasam fund. Tamil Nadu pays 13 to 14 lakh rupees. Government of India has spent 10 crore rupees on maintenance of the infrastructure of the Amarnath Yatra. Rajasthan government in 2017-18 budget, they had spent 39 crore rupees on Devsthan department. Madhya Pradesh, they sponsor the senior citizen trips to Ajmer. Gujarat, West Bengal, in these two states, in the Muslim imams, they are on the state's payroll. State pays the salary. In Karnataka, in the 2016 budget, 16 to 17 crores were spent on churches. In Bihar, out of 4,000 madrasas, 1,127 are run by the state government. Then in UP, 800 crore rupees was spent on the pilgrimage to Kashi, Mathura, Ayodhya. 394 crore rupees was given to madrasas, right? So the state spends lot of money on various aspects of religion. These things do not violate the constitution. We had this concept of Hajj also. So Hajj was basically what? The airfare given to go on a Hajj pilgrimage, around 2.2 lakh rupees. That has now been stopped by the central government in 2018 only. And 2018 onwards, central government does not fund your Hajj journey, your Hajj pilgrimage. And the money which was being used, around 225 crore rupees, is now being spent on what? On providing education to minority girl child. Okay. Searching anything for atheists, nothing for atheists. You don't believe in anything, you know, don't need anything, right? So nothing for you. Then this is Article 27. Next is Article 28, freedom as to attendance at religious instruction or religious worship in educational institutions. What does this mean? This means that in our country there are three types of educational institutions categorized. Educational institution type 1, in those schools and colleges which are owned, administered by the state, instruction of religion. What kind of instruction? Religious instruction is not allowed. In all those schools and colleges which are owned and controlled, administered by the state, instruction which is religious is not allowed. Second, in all those schools and colleges which are recognized, aided by the state, instruction is allowed, but with parents' consent. Parents' consent. So, instruction is allowed, but the consent of parents is required in those schools and colleges which are recognized or aided by the state, which get some government funds. And in these schools and colleges also, if you have crossed 18, then your permission is required. So you may choose to attend those instructions or may choose not to attend those instructions. However, in any of those schools and colleges which are set up by religious denomination and charitable trust, instruction is allowed, and you can be forced into studying or taking those classes where religious instruction is being given, how to worship, etc. These kind of instructions can be given. One more point: if there is any school or college which is teaching, say, the lives of great men or lives of some religious people, lives of gods, etc., stories of Ramayana, Mahabharat, Prophet, Jesus Christ, Guru Nanak, all these things, any kind of chapter in your book, in your text, which relates to these kind of things, they are not religious teachings. They are moral science lessons. Lessons we can learn from great men, saints, gods, etc. So please don't think of it as religious instruction. A chapter on Guru Nanak is not a religious instruction, it's a moral science lesson. That's it. We are done with articles 25 to 28. Look at this question, very simple. You can address it now. What can France learn from Indian constitution's approach to secularism? What is France? France is just symbolic of the Western model, and India, which follows a positive approach of secularism. So, what can the Western countries learn? We have seen the advantages, the benefits of Indian secularism, the protection of religion, the protection of minorities, the protection of people within a fold. All these things can happen because India follows the approach of principled intervention or principled distance. This approach is followed. Okay, so that's it. Please write this answer. You can get help from the chapter 8 political theory book also, the chapter on secularism. Moving on to articles 29 and 30, the cultural and educational rights. What are these two articles? Article 29 says the protection of interest of minorities. So this article provides for protecting the interest of minorities. Any section of citizens residing in the territory of India, right, or any part thereof, having a distinct language, script, or culture of its own, shall have the right to conserve the same. So, any section of citizens residing in the territory of India or any part, they have a right to a distinct language, script, and culture of its own, shall have the right to conserve their language, script, and culture. Number two, have you seen this article anywhere? Tell me. Earlier, no citizen shall be denied admission into any educational institutions maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language. This was seen under the Champakam Dorai Ranjan case. Article 15. And then we added one more clause in the Indian Constitution to the First Amendment Act, Article 15, Clause 4, which says that the state can provide for reservation for SCs, STs, and SEBCs in all colleges, schools, etc., which are aided by the government. Then, Article 30, right of minorities to establish and administer educational institutions. So minorities have a right to administer their educational institutions. All minorities, whether based on religion. So in our country, minorities are of two kinds: based on religion, based on language. So one very important point: minorities not defined in the constitution but recognized. So we recognize that there are two types of minorities: one religious, the other linguistic. But whether is there any criteria for minority, that is not defined. The Supreme Court says that religious minorities are on a pan India basis, country-wide basis. So we have 6 religious minorities in the decreasing order of their population: Muslims, Christians, Sikh, then Buddhists, then Jains, and then the Parsis, the smallest of the minorities in the country. So minorities are on a pan India basis, meaning if in a state Hindus are less than 50%, they will not get the minority tag. Okay. Linguistic minorities are on a statewide basis. So you can get the status of a minority in a state and still be a non-minority in some other state. Okay. Now, second clause says that the state shall not, while giving money, aid to educational institution, state shall not discriminate between those schools and colleges which are run by minorities and those schools and colleges which are run by non-minorities. No discrimination while giving funds to the schools and colleges. Now, Supreme Court has, it is very important to understand the idea of MEI. What is MEI? Minority educational institutions. MEIs. So, Supreme Court has in the TMA Pi Foundation case, 2003, said a very important and a pertinent line. It said that, see, every minority group has a right to preserve their culture, etc. So we want to, of course, preserve the rights of minorities, but we also need to ensure that there is a balance. Ensure what? Standards of excellence that there's a balance. Yes, you have a right to manage your or protect your culture, etc. But when you are running a school, you are also giving to this nation future generation. So we need to ensure that your school, your college also has minimum standards of excellence met. So Supreme Court has given some guidelines. Number one, that anybody, not just minorities, anybody can set up school or college. Clear? Number two, any aided MEI. What is aided MEI? Those MEIs which receive government funds. Any aided MEI will have to take in certain number of students from non-minority communities also. Okay, non-minority communities also. So some kind of reservation can be provided in these MEIs for non-minorities if the states decide. Number three, what will be the admission procedure that the state can prescribe when it comes to all those MEIs which get government funds? What will be the criteria to select students? All these things the particular state can provide for with respect to ensuring standards of excellence. Apart from it, even those MEIs which don't get government funds, in those MEIs also, yes, you can have your own admission procedure, but it should be fair and transparent, because Supreme Court in 1989 had made a statement that everyone, I mean MEIs, of course have a right to administer your educational institution, but you don't have a right to maladminister it. So administration should be proper. Don't mismanage it. And lastly, the state can prescribe minimum educational qualifications for teachers and principals for both aided and unaided MEIs that can be provided. Supreme Court has upheld this on number of occasions, including this being upheld where, with respect to as recent as January 2020 in West Bengal. Okay, so this is with respect to MEIs. MEIs can be aided, can be unaided. So a lot of MEIs, even some convent schools can be aided, some can be unaided. It all depends. We'll have to ask selectively the school to tell us, give information on whether it is aided or unaided, or ask the government to give information whether they are supplying funds to the school or not. Okay. If you want to know whether any MEI wants to is aided or not, you please ask the government. Government, if it is giving funds, then that MEI is aided. Otherwise, it is unaided. Okay, that's it. We are done with our 5 fundamental rights given to us, which we enjoy. Lastly, just a couple of points on right to property, because right to property, uh, what is the current situation now? We should know as far as right to property is concerned. First up, Article 19(1)(f) was the right to property for every citizen. Right to acquire property, to hold property, to sell property. That was there. Apart from this, Article 31 was also there. It said that the state can compulsorily acquire your property. Compulsory acquisition of property can take place. But no person shall be deprived of his property save by authority of law. Nobody will be deprived of their property except by authority of law. A law has to be followed. So law has to be made, and when the law is made, your property can be taken away. Simple. Number two, when your property is being taken away, it can be taken away only for a public purpose. So when the government takes away your land, there should be a public purpose for the land. That maybe they have to build a road, construct a bridge, etc. And there should be a law there should be a law to take away your land. There should be a proper law in place. Only then can your property be compulsorily acquired. Okay? And when you take away your property, we'll give you land. Don't worry. The land rehabilitation laws are there in the country, which take away land and give property to the people, money to the people. And sometimes the money is way too much, right? Depending on where your land is. This used to be the right to property. Now, through the First Amendment Act, some changes were made in the Constitution. Change number one, a separate Article 31, capital A, was added. Okay, this was added through the First Amendment Act. What did this article say? It said that the state can make laws for acquiring large estate properties. And when the state makes such a law, those laws can't be questioned on grounds of violating fundamental rights. Why? Because there was an Article 13, Clause 2, which said that the state cannot make a law. So now the state amended the Indian Constitution. Yes or no? Amendment was done. This was the amendment which was upheld by the Supreme Court also. That yes, Shankari Prasad case, very good. Parliament can amend fundamental rights. So they actually indirectly amended fundamental rights. They made an amendment and said, under this amendment, if you make any kind of law, that law will not be challenged. Why? If the law violates any right, then it won't be challenged. The law can violate a right, but the law was made under amendment of the Indian Constitution. Clear? Not just this. One more article was added, 31B. Now, what is this? This is a very beautiful creation of the Parliament. Parliament said, we are now making a box. Let's call that box Schedule 9 towards the end of the Constitution, because originally we had 8 schedules, then the ninth one. If we make any kind of law, and we place the law in the ninth schedule, then that law will be immune from judicial review. Are we clear on this? If you make any kind of law, you take the law, throw it in this box. This box is called Schedule 9. If the law is thrown in that box, you cannot question that law. That law is immune from judicial review. Judiciary cannot question it, whether it is constitutionally valid or not. Do you think this is a good idea? Having such a Schedule 9? Because if you create a schedule like this or a place like this where the parliament can make any kind of law, let's say the parliament says, India, removal of Democracy Act 2023. India is no longer a democracy. Narendra Modi is the new king. This law is passed and this law is now put in Schedule 9. It can't be questioned by judiciary. Do you think it is a right thing to do? Of course not. We cannot give absolute power to the state. Why? If you give absolute power to the state, it violates rule of law. Limitation on the state's power, rule of law gets violated. Clear? So limitations have to be placed on Schedule 9. This matter was challenged in the court, and finally in the IR Coelho case, Supreme Court said that, see, please understand, till Keshwanand Bharti judgment, till the Keshwanand Bharti judgment, there was no concept of basic structure. But after 1973, the Supreme Court has given the concept of basic structure. Now, if you make any law and put it under Schedule 9, then judiciary can check the validity of those laws on the grounds of basic structure. Only basic structure, but on the grounds of basic structure doctrine. So, on these grounds, the Supreme Court can check whether any law put under Schedule 9 is correct or not. So, now the immunity given to Schedule 9 laws is no longer available. Are we clear on this? In fact, Supreme Court said, and rightfully said, that it is not permissible for the legislature to escape the scrutiny of basic structure doctrine by finding manifestly, inherently cunning ways to get around it. So, Supreme Court called this a cunning way to get around the basic structure by passing any law and putting it under Schedule 9. So, in the I.R. Coelho judgment, Supreme Court made this statement, right? See, so far after 1973. Why this date only? Because this is the date of the judgment of Keshwan Bharti. So after this date, there have been so many laws, more than 200 laws placed in Schedule 9, more than 200 laws. My point is, how many laws has the Parliament, Supreme Court reviewed? None. They don't have time only, but they say we can. They have not, but they can. So right now, this complete immunity of Schedule 9 is not available. Even if you place laws under Schedule 9, they can still be challenged in the court, but on only one ground, that they violate basic structure doctrine. On no other ground can they be challenged. That is the I.R. Coelho case. Lastly, during 1971, amendment was made and one more Article 31C was added. Now, the context of Article 31C will be explained better if you can understand these two articles. These are two DPSPs, 39B and 39C. What are these two DPSPs? The first one says, the state shall, in particular, direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. Meaning, if there are resources for the state, the of the country's resources are meant for everybody's benefit, not just for few people. And second one says, the operation of the economic system should not result in concentration of wealth in the hands of few people only. Don't make such laws which benefit only the rich people, which ensure concentration of power and wealth. Make laws which remove concentration of wealth. Land reforms, for example. What are land reforms? Taking land from rich, giving to poor. What is that? Works exactly opposite to concentration of wealth. Works in favor of this country's resources for everybody. But Indira Gandhi government said that whenever we try to go for all these welfare measures, taking money from rich and giving to poor people, the rich always run to court saying Article 14, equality, Article 19, property getting violated. So a separate article was added, 31C. This says if a law is made to give effect to either 39B or 39C, that law cannot be questioned on the grounds of violating Article 14 or Article 19. This means what? This means that Article 39 clause B and 39 clause C, they are superior to articles 14 and 19. Are we clear on this? Because even if 14 and 19 are getting violated, if the government's target is to provide welfare, they have every right to provide welfare. You simply cannot question them. They have a right to provide welfare. So these are Article 39B and C. We'll be studying the other clauses when we study DPSPs. Clear on this? Okay. Now, later on in 1976, Indira Gandhi government also said one more thing, that see, with the 42nd Amendment Act, we are expanding the scope of 31C. What she said was, from now onwards, if we want to give effect to any DPSP, Article 14, 19 may be violated. Sorry. Now, Supreme Court cancelled this, saying, no, it is too much. In a Minerva Mills case, Supreme Court cancelled this, saying, what is this nonsense? How can you violate 1490? When you see DPSPs, hopefully tomorrow, you'll realize that most DPSPs are very, very vague, right? Very vague. So we cannot claim all those things. And if you are saying that for DPSPs we'll violate 14 and 19, DPSPs cover a very wide gamut of things. So then practically there is no 14 and 19. So that part was cancelled by the Supreme Court in the Minerva Mills case 1980. Just a piece of information. In 1970s, 1976 only, one more article was added, 31D. This article was said that if the government made any law to check anti-national activity, that law can't be questioned by judiciary. Complete harassment of people. Look at the provision. The government says that if we make any kind of law to check anti-national activity, sorry, Supreme Court, you can't question it. You'll make some stupid kind of law to randomly arrest people if they raise questions against you, and then you will say, judiciary, don't check it. We have made a law for anti-national activity. Every leader who may have nothing to perform and show for in terms of work wants to legitimize power using nationalism. Always remember, whenever any group, any people, any government focuses excessively on nationalism, there is some problem because they have nothing else to show for. Sadly, that's the reality. Anyway, when Janata Party came to power, they repealed this provision. Thankfully, good riddance with this provision gone. That's it. Article 19, 31 1 and 31 2, right to property. Now we have exceptions 31A, 31B, 31C. In 1978, when Janata Party was in power, they took a step. They repealed right to property only. So this Article 19, if you see here, it was repealed. So no longer do citizens enjoy this right to property. It's gone. 31 clause 2, gone. What remains is 31.1. This is there, and it is made a constitutional right under Article 300 capital A. A constitutional right. How? So what we have done is, we have taken, this is your constitution. In the constitution, this is, think of it as part 3. Okay? This is part 3. In part 3, there is an Article 31.1. What we have done is, we have taken this article from part 3 and thrown it somewhere outside part 3. So right now, this article is a constitutional right, but no longer a fundamental right, because only those provisions are fundamental rights which are under part 3. Are we clear on this? right? So this is a current situation with right to property. Solve this question first. Came this year only. In India, which one of the following constitutional amendments was widely believed to be enacted to overcome judicial interpretations? Why have you marked 42nd one? 86th Amendment Act is wrong answer, of course. Why? This was meant for education. 44th is also wrong because it was done largely to correct the wrongs done by the 42nd one. First Amendment Act. Remember, First Amendment Act, when the Supreme Court said that in the Champakam Dorai Ranjan case, what? Supreme Court said that Article 29, Clause 2 is getting violated. Sorry, we cannot tolerate all this nonsense. What is this? Madras communal government order, reservation of seats, cancelled. What did the government do? It made the First Amendment Act 1951 to insert Article 15, Clause 4. Yes or no? To overcome the judicial interpretations. Same thing happened with respect to the judgment in Patna High Court on land rights. When the questions were being raised that these land reforms are violating fundamental rights, again this Amendment Act was promulgated to add Article 31 capital A, 31 capital B, one Schedule 9 was added. So it was the First Amendment Act which was brought to modify, to get around, to overcome judicial interpretations. 42nd Amendment Act was made largely to provide a lot of powers for the government. It was meant for the government to get the powers. Clear on this? That's it. One more question asked in 2021. Please mark the answer very, very carefully. Think twice and then mark the answer. Don't jump. Read the statements. Of course, see, right to property right now is under Article 300 capital A. Yes or no? So it is a fundamental right. It is not a fundamental right. Is it a legal right? Yes, of course, it's a legal right. Constitutional right. Legal right. It is a legal right. But available to citizens or any person? Any person. Why? Because this Article 31(1), which became 300A, says that No person shall be deprived of his property. Okay, it is not meant for only citizens, it is meant for non-citizens also. This is what is now Article 300 capital A. I hope this point is clear now. Okay, great. With this, we now come to the last provision. And if you ask Ambedkar, he says the most important provision. So Ambedkar said that if I was asked to name any particular article, nobody is asking him, but he said it. That if you ask me, Ambedkar saying it, if I am asked to name any particular article in this constitution as the most important, an article without which this constitution would be a nullity, null and void, useless, I could not refer to any other article except this one, except Article 32. It is a very soul of the constitution, the very heart of the constitution. It is the very soul of the constitution and the very heart of it. Ambedkar. This is what he says with respect to the Article 32. Okay. So for you, somebody else could be your soul. For the Constitution, Article 32 is the soul according to Ambedkar. Soul, S-O-U-L, not S-O-L-E. Don't make a mistake there. So what is Article 32? Article 32 provides for remedies, issuing writs. Clear? And very important to know that if your fundamental rights are violated, you can go to Supreme Court directly to Supreme Court. Of course, you can go to high courts also. Article 226. But you can go to Supreme Court directly. Now, there is a judgment of Supreme Court which says that you please go to high court first. So when your fundamental rights are violated, yes, you can go to Supreme Court directly. But in the PN Kumar case 1987, Supreme Court has said you firstly go to high court. Move to high court first, then appeal in Supreme Court. Okay, so ideally, even if you go to Supreme Court will tell you to go to some high court only. But yes, as per the constitution, you can go to directly Supreme Court also. Clear? Now one more thing. In the Rupa Hurra case, Supreme Court has clarified that high courts are not subservient to to the Supreme Court, not junior in any sense. So high courts and Supreme Courts cannot issue writs to each other. Very important. Supreme Court and high courts can't issue writs to each other. This is not allowed. High Court cannot issue orders to Supreme Court. Supreme Court cannot issue orders to High Court. It is just that when a case is appealed in the Supreme Court against the High Court judgment, Supreme Court has right to give a judgment. It does not mean that the Supreme Court is giving orders to High Court judges. That is not how things function. I hope this point is clear. Okay. And in case you want to enhance the writ, what is writs? Any idea? Do you remember? What are writs? Can you have some people writing the meaning of writ? Nobody. What are writs? Okay. Writs refer to orders. Writs are directives. So, as of now, the Supreme Court can issue writs only for the protection of fundamental rights. But the Parliament can increase this power of Supreme Court by a simple majority. Are we clear on this? Now, what are the various types of writs available to us? Writ number 1, habeas corpus. Habeas corpus means to have the body of. Now, this writ can be best explained through a very typical standard example that I use. So, you must have seen the movies of 1970s and 80s. If not, I'll tell you the typical plot of all such movies. In these movies, what used to happen was that the hero, belonging to a poor family, topper in college, great in the sports, singer, dancer, musician, teetotaler, well behaved, decent, but attitude problem, arrogant. And because of his arrogance, is unable to get a job, always fights in the interview. But somehow he falls in love with a rich person's daughter only, right? Now they fall in love, keep on singing, dancing here and there in the park. And this rich girl's father, he is taking his car and one day finds them, spots them dancing in the park. Comes back home, is waiting angrily. This girl comes home, singing, giggling, dancing as you do in love, very happy. Then the father takes the girl to her room, climbs the stairs, and throws her in the room. The girl falls on the bed, starts crying, and the door is locked from outside. So, standard, typical story. Now, what does a hero do? Hero is very upset, crying, sad songs, making sad songs, breakup songs, right? Drinking, etc. The problem is that hero has not read polity properly. Had he read polity properly, he would know that he can simply approach the High Court or the Supreme Court. Ask the High Court or Supreme Court that court, please issue a writ order to the father. Ask the father to present the girl in the court. Why? Because her personal liberty has been violated. She is being held captive in captivity against her will. That has been violated. And the court must issue this order. Okay, it can be secured as a matter of right, meaning courts cannot refuse it. The court will issue an order. Are we clear on this? The court will issue an order. The girl is presented in the court. Later on, the girl can tell the guy, who are you? I don't know you. That may be possible. It depends on your strong bond and all. That I can't comment on. Clear? So this is how habeas corpus is used. It can be used against a public body, example police, where it is largely used, or even private individuals like the rich person's, this girl's rich father. So in future, if ever this thing comes to you and happens to you, please use habeas corpus. Don't sing sad songs. Nothing will happen by singing sad songs. Rather, act accordingly. Are we clear on this? Now, but act based on your own repercussions. I am not liable to anything that happens to you later on. If the person says, who are you and all, then it's you who will be under mental trauma. So please. I hope this point is clear. This is called habeas corpus. This is a bulwark of individual liberty, right? And there is no locus standi, mind you, no locus standi whatsoever in habeas corpus. Anybody can approach the court. Anybody. So you can approach the court seeking a writ of habeas corpus against anyone. I hope you remember what is locus standi. We discussed this term under PIL. For those who don't know or are not revising, only God helps you if you believe in God. Otherwise, nobody will help you. Okay, this was habeas corpus. I think we have understood it. Let's move on to the next one, that is called mandamus. Mir Shabir. If she says, "Who are you then?" and then your love was not genuine enough. I'm sorry to state that you could not arouse genuine emotions in the person. Please love better next time. Next is mandamus. Okay. What is mandamus? Mandamus means to command, order. So when you go to the government offices, especially some banks, I don't want to name those banks, the bank employees are working very hard in playing Candy Crush or Solitaire on computer. Remember those banks? When you go to those banks, link failure, lunch break, all these things are there. So the staff are always on lunch break, or there's always a link failure, or printing passbook printing machine never works. So let's not name that bank. Why to name any bank? They're also improving only. Server down, whatever reasons they'll give. So if any government official has failed to perform his tasks, you can approach the court and ask the court, please order the person. He is not performing the tasks. Are we clear? So this is called mandamus. You command, the court commands the person perform the task. Now, this is issued only against public officials, meaning you can't go to court and say, "Court, command my father to give me a mobile phone right now." Please don't try all this. This won't work like this. The court will firstly scold you, and when you come home, then you'll be given a very nice treatment at the hands of your parents also. So please. Now, of course, this MP, this mandamus can be used for private individuals also. Yes, it can against them also. But if they are performing a public function, against private individual also, if performing public function, meaning all those people, contractors, if you have a contract to build a road, that's a task of government. The government gave you a contract, you are performing a government function. So for that job, we can ask the court to issue an order to you. Now, the court may refuse this also. It can be refused. What if you go to court and say that, court, I had gone to this bank, the bank officials are not giving my loan, give me loan only, please ask them to give loan. The court asks the bank, what happened? The bank says, sir, this person has no income and he wants a loan of 10 lakh rupees. For what? For partying and enjoying. And says that once I clear UPSC, I'll return the loan. And looking at his behavior, we have no hope of him clearing UPSC. So hence we have rejected his loan. So mandamus can be refused because it is very much possible. Say, let's say on a very logical and serious note, if you go to a government office and the work is not being done, it's possible that the government is understaffed, the office has lesser staff, some staff are on leave, etc. So your work can be delayed. So this may not be issued as a matter of right. The courts can refuse to issue it. Number two, This can't be issued against president and governor. You can't go to the court and say, court, ask the president to sign the bill. Then what's the point? Okay. Also, plus the legislators also, with respect to making laws, you can't go to court and say, court, issue a writ to parliament to make a law. That's not possible. So, in certain areas, this mandamus may not work. Clear? Number three, prohibition. What is the meaning of prohibition? What is the concept of prohibition? See, as far as prohibition is concerned, a very, very simple and logical point here to be noted is that prohibition and certiorari are one and the same thing. These systems work within the courts. Prohibition is to forbid. Now, let me give you an example. In our country, as most of you would know, see, people under 18 would not know, but others would know that marijuana, ganja, is illegal in the country. So please don't try all these things. Okay? So let us say you are somebody who wants to smoke ganja. People under 18, ganja is a very bad thing. Just think of this, something very bad. This is a first. I knew it very well. Mr. Vivek, what is a ganja? A ganja is a very bad object. Just think of it as something very bad, bad drugs. Stay away from it. Okay? Some kind of drug is there. Now, you go to the lower court. See, these kind of petitions are filed in the court. I'll give you a live example of this kind of a case. Once a case was filed in the Supreme Court, Article 21. See, Article 21 is a very wide article. Right to life includes various things. So once a person went to court, he said that, court, I'm suffering from this day job, 9 to 5 kind of a job. I'm suffering on a daily basis. I work 9 to 5, come back home. And once in the evening, I come back home after getting the scoldings of bosses, etc. I come back home, sit, and I want to enjoy and relax. I want to relax and enjoy. And I open a bottle of whiskey and take a sip, couple of pegs, and I feel relaxed. And I forget all the worldly problems. So please issue this judgment that right to drink and forget worldly problems should also be a part of Article 21. True petition. And the court said, leave immediately from this court. So sometimes people go to court for these kind of things also. So what if somebody here, some aspirant, he says, goes to a lower court and says, lower court, please, why don't you read Article 21, that right to smoke ganja is also a part of Article 21 because it improves my memory, it helps me retain information, or it controls my uh, emotions, it calms me down, whatever your logic is. It helps me forget my loved ones. Now, when you go to the lower court, please understand, you are asking the lower court to interpret Article 21. Subordinate courts have no such power to interpret the constitution, only high courts and Supreme Court. So, you have filed a case in front of a wrong court, a court which had no power to take up such a case. So, if this happens, then the higher court, High Court or Supreme Court, can issue a writ of prohibition, prohibiting the lower court. Lower court, please, this is not your power. Don't dare to take this case. It is issued against a lower court about to begin proceedings in a case over which it has no jurisdiction. It prevents the lower court from usurping, taking over, capturing jurisdiction with which it is not vested. The power is not given to the lower court. Don't try to take that power. Higher court will immediately stop the lower court, called prohibition. preventive in nature. Yes or no? It prevents the lower court from committing a wrong of crossing its jurisdiction. Now, what happens is, what if the court takes up the matter on the same day? The judge is also like you only, waiting. Somebody file a case. I also want to smoke ganja. And he takes up the matter immediately. The lower court starts the proceedings. Okay? Lower court starts the proceeding only. Then High Court can again issue an order, say, lower court, wait, how dare you start the case? Is it your power? It is my power. I will decide whether you can smoke, take drugs or not. Come on, send that case to me. Transferring the case to itself. Certiorari, or the lower court has given judgment also. You file a case, the same day the judge says, okay, what do you want? Article 21, right to smoke ganja, given, interpreted. From now onwards, right to smoke is a part of Article 21, and you and the judge start smoking there only, immediately. Judgment given. Again, see, whether the judgment is appropriate or not is of no concern. The point is, the lower court has no right, the subordinate court had no right to read Article 21, interpret Article 21. So, whether the judgment was very good or very bad, I am not questioning that. I am simply saying that the lower court had no authority to interpret fundamental rights. So, higher court will cancel, cancel the verdict and transfer the case to itself. This is called certiorari. I hope this point is clear. Prohibition means to prohibit. Now, of course, the high courts will not know all these things. Somebody goes to high court and says, in one lower court, a case is filed. High court comes to know, issues a writ of prohibition. Lower court, don't dare to take up that case. It is beyond your power. Leave it. Don't. Certiorari, when a case has been accepted, then high court will transfer the case to itself, or if a judgment was given, high court will cancel the judgment. Lastly, quo warranto. Quo warranto. What is this quo warranto? See, quo warranto is available again to any person. No locus standi. Anybody can approach the courts and all. So, what is quo warranto? Simple example. Every time Mr. Rahul Gandhi contests elections, somebody goes to court and says, sir, Rahul Gandhi, how dare he contest election? He is not even an Indian citizen. And then the court says, Rahul Gandhi, prove whether you are eligible for the post or not. Are you Indian citizen? Then Rahul Gandhi has to prove again that yes, sir, I'm an Indian citizen. Quo warranto means by what authority? Do you have the authority? And for those who have seen this movie, I will not make any comment. I know diehard fans of these movies. So, of course, do you have the authority to take up such a case, to hold such a post? So, quo warranto is a writ issued against persons occupying public positions if they do not satisfy the basic qualification to hold the position. Okay. So, I'll give you a better example. The name of this movie is Vivah, for those who have not seen it. The famous dialogue, Aap Jal Lijiye. You will have to watch it to understand it. Anyway, so ignore this. Ignore this meme. Vivek, you firstly ignore it immediately. What does the pic say? Ignore it. I'll give a better example that you may understand. So, people here, innocent people, keep on asking all these questions. Don't revise, don't study. Some of you. What if somebody wastes time every day, just wasting time here and there, uselessly watching YouTube, right? Creating nuisance in the life. Eventually, you reach the age of 32 and you have not cleared the examination. Now you feel very bad, right? You think, if I could get one more chance, I would study this time. A friend of yours comes and he or she says, see, I will get you a certificate, a caste certificate. Don't worry. I'll get you a false caste certificate. You sit for the exam and you show the certificate. You say, okay, uh, I will start studying. You start studying, sincerely revise, read, solve questions, write answers, and this time you clear the examination. And Raj Sabha TV, Z News, NDTV, all these people come to your house and you are giving interview, party happening after a selection, top 10 ranks. Everybody is happy except your neighbor. Neighbor is unhappy. That's their duty to be unhappy. And neighbor also knows how dare this person clear the examination. Neighbor knows your entire life activity. So neighbor goes to his house. He takes out this diary that he has kept for you, because every neighbor's task is to keep a diary, maintain diary on the people in their society, to tell the parents where the kids are roaming. This neighbor finds out that this person was age 33 now. How can he clear the exam when he is not of the age? Your neighbor goes to court, files a writ, files a petition, asking court, ask this person to prove that he was eligible to sit for the examination. A writ is filed, the court asks you, and if there is merit in the petition, the court will say, sorry, how dare you file false information, removed from the post. You can be removed. Quo warranto. This is the writ of quo warranto. This is how these writs work, these five writs. Are we clear on this? Please solve this question, the last question for the day. Okay, easy question. Actually, elimination. Mandamus will not lie against a company even though it may be a government company. Mandamus, if it's a government company, Mandamus does lie against it. Two is wrong. Remove this, remove this, remove this. Any public-minded person can be a petitioner to move to the court, of course, and mandamus will not lie against a private organization unless it is entrusted with the public duty. Yes, until and unless you're performing a public duty, we cannot use mandamus against private individuals or organizations. So one is correct. C, 1 and 3 only being the right answer. That's it. And we are done for the day. Okay, that's all for me, guys. Jai Hind. Let's meet tomorrow. And political theory, monthly magazine, revision of PPTs. I believe you must have now finished Yojana and Kurukshetra for the month of July. If not, by tomorrow, you will finish the month for July as well. Editorials, read them, and solve the PYQs. That's it. Task for the day. No need to make notes from editorials. If you find some nice quote, etc., copy it in your notes. Chandrajyoti, warrant, a permission issued to arrest somebody. Okay, leaderboard. I forgot. Leaderboard. Only one topper, Shreyank. Excellent. Then Janvi Upadhyay and Sri Hari are at number 2. Then Kirtana, Govind, Pragya, Fani at number 4. Himanshu Pathak, Khushi, Himanshu Manoj, Bhavan, Neeraj Surya, Lucky, U Subhash Chandra Bose, Ghanshyam Rathod, Hilo at 8. Then others at 18. Great, we have a single topper today. Nirbhay, in what case do you want them to be used against MPs? To vote on a bill? No. I think I have clarified it. Mandamus can be used against MPs in what case? On voting in the parliament? No. To perform their tasks otherwise? Yes. Vivek, I will not be addressing this concern. I mean, whatever I say, you take the exact statement and ask a question mark in front of it. This is not justified. Please improve that behavior of yours. Just because we don't know you, we don't see your face, does not mean you misbehave like this. Have the decency and courtesy to respect the forum and platform. Chandu, 7 to 8 hours. You, Subhash. Very good, sir. Why Megha? What is a big deal about it? I don't see it difficult. The explanation is there. Try for it. It's okay. If you leave and skip those parts, this becomes pending. It will never be complete. Vivek, ignore the phrase. That phrase has no relationship to our studies. That's it. Second statement, Vanshika, in this, a mandamus will lie against government officials, government companies, PSUs, etc., not against private individuals. Chituri, Google search for it, you'll get the information. Pratima, somebody has to file a habeas corpus plea, right? It's not Anjali, not injection, injunction. Injunction is a lawful order of a court asking a person to do something or refrain from doing something. That's called injunction. Injunction with a generic legal term, which means the court asks somebody to do something or asking someone not to do something. Okay. Sarita, revision. That's it. Nikhil, in 2019 only it was modified. So what I said was correct. Google does not give any kind of information. Google gives you a link, which is a link to a website which gives information. Don't say Google told me this. Google will not tell you anything, right? There is no page of Google to give you information. You must have accessed some link to some website, and that website has old information. What can I do? I cannot go and correct websites. I can only give you the information given by the government. Srimant, read editorials. Anjali, hopefully tomorrow. Janvi, groups. Shivani, uh, no, it is for public posts only. That's it. Mangla, as many times as possible. There is no limit. Anshu, e-governance is a part of governance. That will be taken in the governance lectures. Bhavya, I don't think that is cause of concern for this class. Good for YouTube videos to create divide in the country, but not for this class or UPSC. Okay, Bhavik, happy birthday in advance. Okay, that's it. Let's meet tomorrow. Till then, that's all for me, guys. Jai Hind.